Thank you for having me. I'm happy to be here with you guys this morning. My name is Stefanie Lipson. I'm a partner in the private client services group here at Greenberg Glusker. I handle all things domestic, international relating to private client, whether that is wealth transfer as a primary focus of planning, as well as the income tax, property tax, and all sorts of other tax considerations related to private client transfers. So I thought we'd spend the time that we have together today talking a little bit about some of the things that we're seeing in the private client space right now, just as a little bit of, kind of keeping your ear to the ground, things that you might think about as you are working on transactions or speaking with clients or client advisors. So I'm going to start with perhaps the most obvious one, which is the potential tax law changes that are on our horizon, the so-called sunset of the tax law changes.
Mic up just a little bit.
Sort of.
Does that help?
Hold it.
Does it make a difference?
Either that or I'll come back up to the front.
I think you need to come back up to the front. I don't think.
I only have this mic here. I don't have the other mic, but hopefully that's a little bit better. Right now, we are still in the period where we have the Tax Cuts and Jobs Act that went into effect. It was passed in 2017. So in the wealth transfer, state and gift tax world, we have an increased doubled exemption. Right now, with an inflation adjustment, that's $13.61 million per U.S. citizen or U.S. resident. And when I say U.S. resident, I mean a domiciliary of the U.S. I don't mean an income tax resident. But that law is temporary and its sunset is coming up. We have one more full year of it in 2025. So we'll probably have another inflation adjustment for 2025, taking us somewhere close to or even over $14 million of wealth transfer per individual before an estate and gift tax would apply. But as of January 1, 2026, that law will be cut back in half to where it was before the tax cuts. With the inflation adjustment, we're expecting that to be about $7 million per individual. So for a married couple, about $14 million of wealth transfer as compared to $28 million of wealth transfer, which is a real difference. Just for some context, when I started practicing, we were closer to between $2 and $4 million per married couple that can transfer wealth. So we are considerably at higher exemption amounts. So the reason that I bring this up today is not just to say, okay, this tax law change is on the horizon. There are a lot of tax law changes that are going to be on the horizon as part of the sunsetting of a lot of the provisions of the Tax Cuts and Jobs Act. But it's because clients are increasingly focused on what should I do before it's gone? Use it or lose it, I think is the term I hear most frequently. How can I take advantage of the exemption before it rolls back? And we've been here before. We were here in 2010, the 1 year of the estate tax repeal. We were here in 2012 before they passed the law making it so-called permanent, starting in 2013 until it wasn't permanent because they passed a new law in 2017. So we've been here before. The difference this time is we actually have tax guidance that tells us that there is not going to be a clawback if somebody actually gets their full amount of exemption and wealth transfer while they have this increased amount. It is not going to negatively impact them if the law rolls back and they pass away at a time where the law actually has a lower exemption amount. We didn't have that guidance in the past times.
When does the law expire? Is there a date?
December 31, 2025 is the last official day to make those transfers. Again, that's assuming that we don't have a extension of the law. We have some elections I've heard that come before this law expires. So, it remains to be seen. We also have a full year of the whatever new Congress is sworn in, being impaneled before we actually would get to the sunset of this law. And so it's January 1, 2026 that takes where it will take effect if it does in fact roll back. I am not here today to talk about my crystal ball and what I think is going to happen. My crystal ball is very cloudy, so I have given up making those predictions. But what I am going to mention is when clients are interested, when advisors are interested in helping to develop strategies for their clients to take advantage of this increased exemption amount while they have it, one of the things that you also need to be careful of is that we don't just rush ahead and push forward without really looking at what the client has done in the past. And the reason for that is, we have one set of exemption. This is this estate and gift tax, but there's an entire other tax that potentially applies, whether it's a now or down the road tax called the generation skipping tax. And there is often for clients a mismatch between the amount of estate and gift tax credit, the amount of that they can transfer in a current transfer without a tax applying, the estate and gift tax, versus the amount of GST exemption that they have, because we have all sorts of automatic rules that apply for using GST exemption on various prior transfers. So the point is not to, have your eyes glaze over with me in a deep analysis of the GST exemption laws today, but to understand that just because a client says, well, I haven't made any gifts before that have used all my credit, that doesn't mean they haven't used GST exemption. And there's often a mismatch. And so one of the engagements that we are seeing more frequently right now as clients look to take advantage of the increased exemption is also making sure that there's a reconciliation of what they have done in the past. Usually we see that more often happening when we go to file estate tax returns. More and more so we're seeing it now because there are significant gift transfers that are occurring. So that's number one. In the same vein of that, the corollary of that is taking a look at what I like to think about as perhaps creaking structures. Things that have been in place for a little while, but might feel a little bit creaky, or maybe need a little tune-up, if you will. And one of the reasons for that is we have a lot of clients and advisors who we see who have, for example, an irrevocable trust that holds a policy of insurance on somebody's life that's been in place for the last 15, 20, sometimes longer years. Well, how's that policy doing? How's that policy performing? That's not our purview as lawyers to review and analyze, but we also don't want to be complacent and make sure that the appropriate advisors are on the team and are looking at these different structures that have been in place. We have a lot of transactions that involve sales to trusts that have occurred. Have the sales performed in the way that we would anticipate? A lot of these are what are typically referred to as estate freezes. Well, it's only a freeze of the estate if the assets have actually appreciated in value or thrown off cash in order to pay down a promissory note in connection with a sale. So taking a look at these different structures that have been previously put into effect and really reviewing and understanding, are they working as anticipated? Or do they need some review? Because that's going to go hand in hand with also utilizing and thinking about how to take advantage of the increased exemption while it's available. The other part of that is also making sure before anybody forges ahead to doing new planning structures that all of the prior planning trust transactions have in fact been properly disclosed as they are required or supposed to be on the appropriate type of tax return, whether that's an income tax return or gift tax return. And making sure that we have adequate disclosure and that we understand both what happened and that it was properly disclosed in order to make sure that what we are doing on a going forward basis is consistent with that. So as we think about some of these different, and just let me know how I'm doing on.
You're good.
Okay.
Yep, you've got 15 minutes.
Okay, terrific. So as we are looking at the different planning structures, as we are moving forward with these different planning structures and transactions, looking to take advantage of the increased exemption, perhaps while we have it, we also, need to be cognizant that there's a lot of money in motion, right? Money is moving in a lot of different directions, both generationally and cross-border. Increasingly so, our clients are global. Our clients have global ties from a financial perspective, even if they are not necessarily global themselves. And we need to not presume as advisors that a plan is purely domestic. And whether that means that the transaction itself involves a component of international funds where assets are crossing borders, and we need to think about that, or our client themselves has an international tie, whether that's from a citizenship, a nationality perspective, residency, multiple jurisdictions, one generation who is domestic, one generation who is international. We need to presume that not every plan is quite as simple as we think it is, because clients and their wealth ties are now global. Also, as far as money in motion, one of the things that we are seeing is some resurgence of planning transactions and structures that we haven't necessarily seen in a long time. So when I started practicing, particularly, here, for example, every structure I saw, every business entity I saw was a pass-through entity, an S corporation, a partnership, an LLC. I never saw a C corporation. I knew they existed, but those were just those public corporations. We didn't plan with C corporations. More and more so, particularly as it relates to QSBS stock planning, we're seeing C corporations owned by private individuals and purposely structured, both in connection with the deal structure itself, as well as sort of with a lens toward the potential of income tax and wealth transfer tax planning. So that's a different type of planning than when we're talking about pass-through entities. Similarly, there's a love affair, if you will, of wealth planners and private client with what's called a grantor trust, a trust that is ignored in the eyes of the income tax law and is taxed directly to the owner. And you can have a foreign grantor trust or you can have a domestic grantor trust. Here I'm typically talking about a domestic grantor trust. But basically, even though the assets are owned by a trust and they're not owned by the grantor, the person who contributed assets to the trust, for income tax purposes, they are in fact owned by the grantor. At least that's the way that they are reported. And so you don't have a separate taxation at the trust level. It's all just reported on the grantor's personal return. We've had a love affair with these for, quite a while now. But the interesting thing is a lot of the type of planning structures, for particularly as it relates to QSBS planning that has become, very prevalent, you're not using grantor trusts, you're using non-grantor trusts. And so one of the things that is important to really look at, again, thinking back to those creaking structures is my trust, if I'm thinking of it as a non-grantor trust, is it really a non-grantor trust? We've spent, decades now purposely making trusts be grantor trusts, intentionally causing them. Sometimes you'll hear the term intentionally defective grantor trust, which a lot of people don't like because I have a partner here who makes it very clear it's not defective at all. It actually works exactly the way it's supposed to work, but intentionally causing it to be grantor trust. So that's really easy. We purposely are including powers that are causing that characterization. If you want it to be non-grantor trust, just excluding those powers doesn't guarantee you that it's a non-grantor trust. The grantor trust rules were originally designed to say, if you happen to have one of these particular powers, the powers that start in Internal Revenue Code 671, and then, follow, if you have one of those powers, whether you meant for it to be or not, the trust will be characterized as a grantor trust. So it's the unintentional grantor trust that we now need to be thinking about and focusing on. Understanding, well, do I have somebody who has a power to make discretionary distributions as trustee that's going to cause it to be a grantor trust, even though I didn't actually mean for it to be a grantor trust? Does it own insurance and is using insurance and income from the trust to pay premiums on the life of the grantor? Well, that's going to be a grantor trust, even if I didn't mean it to be a grantor trust. So again, going back and reviewing those existing structures to understand, is this working the way it's now intended to be working, as opposed to how I thought that it was supposed to work at the outset? So the other thing that I'm seeing a little bit starting is, again, in the vein of insurance, is a conversation. There was a lot of conversation, I don't know, maybe about 10 years ago or so, on what's called PPLI, private placement life insurance. And then things kind of quieted down a little bit. Then there were some rulings, and now it's kind of starting again. And I actually don't have anecdotally an explanation for you for why it's starting again, but apparently, supposedly, I imagine these things are cyclical. And so there is more conversation occurring around PPLI, both in the domestic planning space and as potential, application in the cross-border planning space. So again, seeing some of these money in motion resurgence of conversations and resurgence of planning structures that perhaps we haven't been utilizing and haven't been seeing. And that's, by the way, I'll say also just anecdotally true as we change interest rate environments, right? For, the last 10, 15 years, we've been in such a low interest rate environment that the types of planning structures and types of trusts and, the alphabet soup of different acronyms that we as planners like to use, whether it's a GRAT, whether it's a, charitable lead trust, CLT, IDGIT, I think is, out there. Many of those are particularly effective and have worked well in low interest rate environments. There's a different set of planning structures that tend to work better in higher interest rate environments. And so again, we're seeing sort of a repopulation and a resurgence of some of those planning structures that we haven't necessarily seen as much in recent years. Another topic I think that we are seeing more and more so, whether successfully or unsuccessfully, is privacy, please. Right? Clients more focused on how to maintain privacy, which I actually think is particularly ironic in the age of, sort of social media and everybody putting everything out there, including what they ate for dinner. But when it comes to their ownership of assets, their locations of residences, the information about trusts that they are creating and what has to be shared about them. We are seeing an increasing desire to implement structures to help maintain privacy. I think that very few of them are going to actually truly be bulletproof. Maybe that's the lawyer in me saying not willing to give a full guarantee. I don't know. But we are seeing this from the simplest of things like acquisition of residence and property, particularly as we see a lot of inbound transfers and acquiring significant residences in various jurisdictions. Even that, that's the simple. I want to maintain privacy as it relates to where I live or where my children are going to be living. Even the simple structure is complex because it is so easy for people to find and dig further information. And so, we're seeing not just that the nominee arrangement or simple privacy trust necessarily is enough anymore, but needing potentially multiple layers involved in that planning structure. But again, those multiple layers, whether you're interjecting a corporate fiduciary, whether you're adding an entity level transfer, that's not only going to increase complexity, you also need to think about, well, where are the funds really coming from? Do we have that international cross-border connection where we need to think about what does this look like from the lens of the jurisdiction where someone's coming from? We know if it works here, but we need to also work with counsel in that other jurisdiction to understand. Yes.
So I guess my question about privacy is that with artificial intelligence, it can really scan the whole internet in seconds in filings. So it can find cross relationships that it takes days, hours and days for attorneys to find, right? And so I would imagine that being able to get any kind of privacy is going to become more difficult than ever.
I think that part of it is going to depend on the level of steps and complexity that a client is willing to engage in. So, for example, on a new acquisition of a property, you can start from a place that the client is nowhere associated with the transaction. They're doing everything through a privacy structure, nominee relationship, multiple level entity managers. Where it's interesting, and I don't know where AI is going to actually pick up on this, where it's interesting is to think about how do the disclosure rules that we're starting to really have domestically interact with this and limit our ability to do this. Until recently, there were ways to really make sure that you could maintain sort of beneficial ownership information about an entity privately. But now we have the Corporate Transparency Act in the United States, where you have to disclose beneficial owner information. And the rules themselves suggest that it's not that there's going to be an online public database, but, again, to your point, we don't know how information is really going to get out there. Interestingly, anecdotally, I would say that the pushback on Corporate Transparency Act, I feel like I hear it more on the domestic side than on the international side, because the international and cross-border planning is used to disclosure requirements. That's, there are registries of entities, registries of trusts, transaction, disclosures that need to be made, particularly transfers to the US or out of the US. And so it's really on the domestic side that we're seeing more of the sort of, being taken aback by the Corporate Transparency Act. So that's going to be for, entities. But interestingly, I'll also note that we don't have it in effect yet because it doesn't take effect until I think a year after it's finalized. But there is a similar set of rules that are going to apply to real estate transactions. And I can foresee that also being particularly onerous, where people have sought to maintain privacy in terms of who the beneficial owner purchasing real property is. So there are a set of rules that look very similar to CTA, Corporate Transparency Act, that are going to apply for real estate transactions that involve a purchase by an entity or a purchase by a trust without a regulated lender. If you have a regulated lender, you're already doing the typical AML and KYC and disclosure requirements. So it's going to be seller financing, hard money lending, no financing. Those are the ones that are going to be theoretically subject to this disclosure requirement.
I think the discipline required is going to be tremendous. I mean, more discipline than ever before. The other aspect also when it comes to privacy is, family related issues where a kid takes photos when he's at his place.
Yes.
It gets, time stamped and location stamped. He posts it on Instagram or something like that.
Absolutely. I think that, for example, even in the simplest of circumstances where a client for one reason or another, excuse me, wants to maintain privacy about the residence that they're purchasing, and they go through all of the proper steps in terms of having a privacy structure in place so that their name is not on title, they're not associated with any of the public records, then they order delivery food service to their own house and have every magazine subscription, and their kids are, inviting everybody over to their house who are taking photos and posting it on Instagram. So, I think that the reality of the way that a lot of people have public lives, and also even just how we now interact in our lives, even the simplest thing of saying, I want to order a pizza, involves you entering your name, address, and your email address and a phone number. So there are clients who have separate phones and numbers and emails for all of that to not correlate with their personal data. But that again takes, I think your word is appropriate, a lot of discipline.
That magazine subscription data, it's a database, it's everything gets, circulated, and actually there's probably a magazine database of 50 million Americans on the dark web you can buy for $500. So,
yeah, but
the best laid plans.
Yes.
It's fascinating.
But I'm actually glad you brought up folks and their families and kids, because I think that's the other place where we're seeing the conversation on privacy, which is, California as an example. If you create a trust or have a trust being administered in California, there's a duty of the trustee to keep beneficiaries reasonably informed about the trust and its administration. There are a number of jurisdictions, Delaware, Nevada, South Dakota, I'm going to name those, but there are certainly others that have what are now called silent trusts or confidential trusts. This is different than a privacy trust. This is a trust where for some period of time, the trustee does not have a duty to inform beneficiaries that they even have a trust being administered for their benefit. There is often what might sometimes be called a designated representative, where that is the person who receives information or notice, if notice is required in some respect, about that trust. So families, again, who are not necessarily prepared to share all the information with their family members, or there's a broad group of family members or beneficiaries, are utilizing and looking to some of these other jurisdictions, again, from a privacy and confidentiality perspective. Yes.
Hey, there's more wealthy Americans who were born outside the United States than ever before, right? And a lot of them choose to reinvest some of their proceeds into their home countries, where it's very difficult to extract the proceeds once you've invested it. So, how do you guys plan around that? Like, for example, if you're, from India and you have investments in India, it's very difficult to take the capital out of India. I imagine it's probably difficult in China as well.
Yeah.
So do you guys write plans around that, or how do you address that? Or
so I think each one is very client specific and jurisdictionally specific. I will say, perhaps I sound like, a broken record saying it over and over again, but it is absolutely essential and imperative to have counsel in that jurisdiction who is reviewing things on a.
Was that the AI?
Yeah, exactly. I brought the lights down. Who is reviewing things on the side of that jurisdiction? Because again, the lens that we look at something from the US, how it's going to be taxed, what the structure means, whether an LLC is taxed as an LLC, whether it looks like a corporation, who the beneficial owner is, all of that on the US side may or may not match the way that the sending jurisdiction, if you will, is looking at it. So do I have a minute or two left?
A couple more minutes. Yeah,
okay.
I think it's remarkable. Yeah, keep on going.
All right, terrific. So I have just one more that I wanted to note for you guys as a, send you off into the sunset, perhaps, that 2025 sunset that we started speaking about. And that is the increasing both prevalence and that we should be expecting an increase in litigiousness and disputes. And, we might say that we are already very litigious as a society. We see contests, beneficiary contests, disputes between siblings, disputes between family members, between trustee and beneficiary. But there is a tremendous amount of generational wealth that is transferring in these coming years. And so we should be anticipating similarly litigiousness surrounding those transfers. And so we see an increase of awareness of clients of that. Also, by the way, dealing with diminished capacity issues as people live longer and age, which brings potential additional challenges depending upon what the planning structure is. So we're seeing clients and advisors focused and trying to have awareness both around how to best solidify the planning structures to prevent that litigiousness, or at least have the winning stronger argument in the event of potential challenges. There are some states, a surprising number of them, to be quite honest, that have what we would call a pre-death or pre-testamentary challenge process. So instead of waiting till somebody has passed away, there is a way to actually prospectively get people to have to make a challenge to the plan before the testator has passed away, or the creator of the trust. And the one hand, that sounds like it might be a little bit, unpleasant, I suppose. On the other hand, the, potential benefit is that the person whose plan it is, who this is what they want, is here to say it. That it's not after the fact, right? And so there are some states that allow that. Some of them are judicial processes. Some are actually non-judicial processes. You don't see a lot of people doing this, but it is out there. And I think part of the reason that you don't see as many people doing it is because it does also require disclosure of lots of information that perhaps families are not necessarily ready to do for all of the beneficiaries.
Can you just talk a little bit about the liability of the trustee of an estate? Because I think that's an issue that's never addressed properly, which is that the trustee really is open to litigation based on how they, execute, the estate, whether it's after death or, pre-death, living will, things like that. So,
Yeah, I mean,
I don't, is there like recourse that where somebody who appoints you trustee can write that you're free of liability or something like that, or how does that work?
yeah. So first of all, I think it's going to vary from state to state to what degree you can offer the trustee protection against potential claims against the trustee, right? The general sort of, status quo is a trustee is a fiduciary and has duty to act reasonably. And in the event that they act unreasonably, they can be held liable. You can lower the standard of care, say that they're only to be held liable in the event of gross negligence, bad faith, willful misconduct, really doing something bad. You can offer indemnities and under the terms of the trust, but then there has to be money for those indemnifications because they don't mean very much without it. But the other thing that we're seeing is we're also seeing various structures. For example, many states, California even now has one, but it's very new, effective January 1, 2024, so truly very new. They have what are called directed trust statutes. So directed trust statutes functionally allow the fiduciary duties to be bifurcated, where you might have an administrative trustee who holds a limited number of powers, but then only acts at the direction of, for example, an investment advisor, a distribution advisor, and carries out those directions. And so that fiduciary, that trustee is going to have a more limited standard of liability, but the investment advisor and distribution advisor have the liability instead. So
our group is living through like a remarkable time where I would say more than half of our group are acting as trustees for their parents because our parents are so long lived. And I would say 80% of the women in our group are trustees for their parents. It's who are 90, 100 years old.
Mm-hmm.
It's such a responsibility. And, people aren't aware of the liabilities. Like I've heard people come to me and say, if I had realized that my making the decision this way versus my brother, in that way would have caused so much of an argument, I would have taken the responsibility.
No, I think that's right. I think that in the context of a business setting, when you're serving as the president or CEO or CFO, you have fiduciary responsibility in terms of how things, or on a board of directors, you're very aware of fiduciary responsibility. You're also aware of D&O insurance, and to make sure that it's protecting you.
Right.
There is fiduciary liability insurance for trustees. More expensive than a typical D&O policy, but there is fiduciary liability insurance out there, because I think that one of the things that we always have to be mindful of is whether you're a family member or you're just a third-party trustee, individual, or corporate fiduciary, you are interjecting yourself into what is some version of a family situation, and whatever is happening in that moment of the decision that you're making. Yes, the decision that you're making has consequences, but it also probably has 30 or 40 years of history behind it that you don't know the dynamics between the people who are engaged in that decision, which is slightly more different than would be the case if you were just operating and making a business
I think
decision.
once corporate actors get involved, the complexity level just goes off the charts. So
yes, you had a question. I think I'm out of time.
Yeah.
Oh, thank you for letting me go over a bit.
Yeah, no, the question is a simple one. How?
Famous
So I'm
last
assuming
words.
you litigate as well.
I absolutely do not litigate.
You do not. So in the litigation department that is handling the structures that you created,
Mhm.
And there's
My
no-
structure's never
and
had
there's a no contest. So you're not even writing it. So whoever's writing the trust, I'm assuming they're putting in a no contest provision.
Yes.
I mean, it's standard. I've never seen a trust without a contest provision.
Mm-hmm.
But I'm a baby lawyer. I've only done it 40 years.
Okay.
So how many successful contests are you aware of in the universe of your knowledge? Maybe once or twice is all I've heard.
So I think that there's a lot to unpack there. So I'm going to do my best. The first is it's going to matter what jurisdiction you're in. So for example,
matter.
it will matter which jurisdiction you're in.
Oh.
So for example, in 2010, California significantly constricted what is going to be considered a contest under California law in order to trigger a disinheritance clause under the document. So there's a lot of things people can do that make a lot of trouble that are not actually a contest, is the way that I try to explain it. If they trigger the no contest clause, I think that it then is actually fairly rigid, I think is the way to put it, in California, and not just the sort of the party who, sort of throws the first grenade, if you will, but also the responding party, if they're also a potential beneficiary, even if they're acting in a fiduciary, because it's any filing. And depending upon what position you're taking, you could yourself be considered to be contesting the validity of a document. So in California, it's going to be one of the sort of direct contest grounds, lack of due execution, fraud, undue influence, a lot of the typical, things that you think of. It can also be a challenge to characterization of property. That's community property. That's not separate property, so on and so forth, or bringing a creditor claim that really doesn't have founding. That's California. And so I do think that if you get to the point where something is a contest, assuming you get through the litigation itself, right? Because again, we also have to think about that there's a lot of settlement in the context of a contest in order to not expend, the estate assets in the fight itself, depending on what it is. I do think that if you're within the bounds of the contest clause, there are teeth to it. Other states have much more. I will also add California pre-2010 had a process. This was when it was a broader, group of things that could be considered a contest. California had a process where you could actually go to the court and say, hey, judge, is this going to be a contest if I do this? Oh, it is? Okay, never mind. I'm not going to do that. You had like a safe harbor that you could ask, can you do this or you cannot do this? Once this new clause went into effect in 2010, where we have a more constricted version of what is going to be considered a contest under California law, there's no more safe harbor. You can't go ask ahead of time. So either you do it or you don't do it and you see what happens. Other states don't necessarily have the same restrictions. California, for those direct contests, there's actually a probable cause standard. So you can bring a direct contest. You can say that this lacks proper execution and is an invalid document. But if you have probable cause for the challenge, you are still not going to trigger the disinheritance clause. You have to lack probable cause for one of those direct contests. Other states, we've seen a lot of that probable cause also come up, but still potentially have broader no contest clause. So one of the things that we are seeing, so thank you for bringing this up, because it's one of the other things I wanted to mention here today, is that we're also seeing a desire for perhaps more creativity in some of the drafting provisions, where we know that we can't necessarily rely entirely on the no contest clause to deter bad behavior, because there is plenty of bad behavior or plenty of questioning that can be done without necessarily triggering a disinheritance clause. So for example, a client who has particularly, unfortunately, there has been litigiousness among the family members prior, and not involved necessarily in the estate, but even in business, has sought to include a provision to ensure that the funds of the estate that would pass to the beneficiaries can't be used to litigate against one another. And so placing some parameters and restrictions, conditions on, what these funds can be used for in order to promote family harmony, is really the way we're looking at it. So I think that some of the provisions about no contest clause also then lend themselves to some more creative thought and drafting as it relates to various family issues to try to focus on how can we diffuse and defer some of those situations.
Fantastic.
So
Thank you so much,
I
Stefanie.
appreciate the
Great
time.
job.